Good morning. We are here for oral argument in cause number 1 CACV 18-0382, Seven Canyons versus Villa Renaissance LLC. These proceedings are being audio and video recorded, so we'd ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel, you're advised that you're responsible for watching the clock if you want to reserve a portion of your time for rebuttal. We have read the briefs. We've discussed this case in conference this morning. Counsel, you may proceed.
Good morning. My name is Kevin Nelson. I'm a shareholder with Tiffany & Bosco, and I'm here representing Seven Canyons Recap LLC, the lender in this matter with the first position deed of trust. With me in the courtroom is Robert Seaton, one of the managers of Seven Canyons Recap, and I'll refer to my client as the lender, or try to at least throughout. This case, if upheld on appeal, is a case of lender beware. And it would stand, if upheld, for the proposition that if a lender invokes its contractual remedy to have a receiver appointed, the superior court may use equity to circumvent or overcome that lender's other contractual rights and really effectively turn the lender into a guarantor for its borrower's obligations. It's our position fundamentally that that cannot happen. And the reason it can't happen is because there is a clear contract controlling the duty to pay assessments here. That contract is a declaration of covenants, conditions, and restrictions that the HOA lives by. It's their main governing document. And that document defines who's responsible for assessments. Each time it defines the responsibility or says that the responsibility lays with the owner. The lender has never been the owner of the collateral at issue here.
But as I understand the record, the lender doesn't own the property. The VR did, and then VR gave the deed and the ownership over to VOA. So VOA seems to own the property under the bankruptcy plan which you agreed to. The first proceeds go to pay back the delinquent assessments, correct?
That is correct. A couple of points, if I can break that down, Your Honor, and hopefully address your question. But the ownership of the property started or began with the borrower. Through the arbitration, it was conveyed, at least the ownership of the 6 wholly owned villas was conveyed to the HOA, and the HOA subsequently conveyed that to VOA Property Holdings LLC.
Yeah.
So that's absolutely correct. The bankruptcy plan does have language within it that says if the reorganized debtors, which is the borrower here, villa intervals are sold after the reorganized debtor complies with its requirement to market and sell those properties, then there's a payout. But the bankruptcy plan, and the payout does say in the first category, assessments are paid, among other costs. Absolutely correct. But the bankruptcy plan does not impose an obligation to pay assessments. It's merely a recognition of the obligation that's established by the CC&Rs. There's nothing within the plan that says that the lender has to pay the assessments or anyone else. It's just acknowledging what everybody knows to be true under the CC&Rs.
Well, when a unit or a fractured unit is sold,
right,
the first cut from the sale under the bankruptcy plan goes to pay the assessments.
That is correct. But it's not creating a new obligation. That would be true if the borrower were going to sell his property at any time. Right. It has an obligation to pay those assessments. What the Superior Court did...
So I don't understand how you as a lender are on the hook for those assessments. Your rights just come after the assessment are paid. Right?
Well, I'm not sure if I'm understanding you. I don't understand how we're being required to pay the assessments either, but that may not be your point.
But what I'm saying is I don't think you are paying them. The receiver, which you have, you followed your right, had a receiver appointed. The receiver is standing in the shoes of the owner.
And that's where I disagree with you, Your Honor. The receiver appointed here was a special receiver. It was appointed only to market and sell the collateral. That's it. It was not a general receiver over the borrower. And that's an important distinction, because what happens there is that the receiver is not operating a business. It's not generating income. It's not taking over the borrower. All it's doing is marketing and selling those units, and that's its limited capacity. If it was receiving income, if it was in the borrower's shoes, the borrower's shoes, then it would be, I think, responsible for certain items. But that's not the issue here. The issue here is that the CC&Rs required the owner to make those payments, even in any sale, no matter under what circumstances. And there's nothing within the bankruptcy plan that changed that obligation. So I agree, in a common sale, in any sale, certain lien rights have to be paid off, but it wasn't to be paid out of our proceeds. And we talk about this within the...
But how is it being paid out of your proceeds if the assessments take precedence over your rights?
They don't. They absolutely do not, Your Honor, and this is why. Because there's a statute, 33-1256b2, that explains that in every circumstance, the lender's first deed of trust, which is what we have here, is superior to assessment liens. It's that clear. And then...
Well, but you agreed to the order of disbursements by signing on to the bankruptcy plan. So while I may agree that in other contexts that statute might take precedence, you apparently agreed otherwise.
Well, we didn't agree otherwise. We agreed to allow those assessments to be paid out in the ordinary course, assuming that the borrower was going to perform under his plan. And it was, remember, you have to look at the language carefully. The language requires the reorganized debtor to market and sell the villa intervals. And it's after the sale of the reorganized debtor's villa intervals that waterfall comes into play. So it's assumed that the borrower is going to be selling these units. That did not occur.
But the receiver is marketing and selling the units, correct?
But it's not correct. But it didn't step into the borrower's shoes because it's not a general receiver, it's a special receiver. And if you look at the black letter law that we discussed, the receivership law that we discussed, and the interplay with the statute, that's really where this all comes together. Because the black letter law says that the receiver and the court both have to acknowledge the lien rights between the parties.
Well, wait a minute, hold on. Are you telling me that the receiver was not obligated to pay out under the terms of the bankruptcy plan?
No, he was not.
He was not?
No.
Okay, if that's your position.
I mean, then let me take a step back and try to explain that again. The obligation to pay those assessments arises under the CC&Rs, period. The CC&Rs define how those are calculated, when they're calculated, and who's responsible for them. Okay,
Do you believe the appointment of the receiver in this case circumvented the plan of the bankruptcy?
I think no. I think that the Superior Court in its ruling circumvented the CC&Rs.
If we pause for a moment and look back at what we're dealing with, when I read the record, it seems the bankruptcy plan stated that those association fees must be paid before any fees or any loan proceeds, etc., are paid to your client. That's the way I read it. So it doesn't ascribe who's going to pay those. It simply says they're going to be paid first, as though it changed the priority of the payment. I mean, it doesn't talk about who's obligated to pay it. It doesn't talk about, it just says unambiguously that accrued association dues must be paid before payments to recap.
I disagree with you, and here's why.
That's what I want to hear.
The plan language required the borrower to take certain actions. If the borrower marketed and sold those units, then that payout would comply with the waterfall laid out in the plan because that's what was obligated, or the borrower's obligation under the CC&Rs, okay? They weren't agreeing to anything different other than the borrower being permitted to comply with its obligations under the CC&Rs for an owner to pay the assessments. And what the Superior Court failed to do is it said, okay, I'm going to look at the bankruptcy plan in a vacuum. I'm going to put my blinders on. Nothing else comes in. And what it had to do is come out and say, look, let's look at the CC&Rs as well. And let's consider what the parties had in mind at the time they entered into this bankruptcy plan. And what the parties had in mind was the fact that the CC&Rs unambiguously say two things. Number one, it states that the owner is responsible for assessments at all time. And number two, it specifically defines an owner to exclude a lender that has a security interest in either a unit or a villa interval. And that's precisely what the lender has here.
But the receiver is selling the property that the owner, whoever the owner is, owns. So once those proceeds are obtained, they need to be dispersed according to the bankruptcy plan, whoever the heck the owner is.
I disagree with you, Your Honor, and this is why.
Then what purpose is the I just don't understand, what's the purpose of the bankruptcy plan if you say, oh, we've already circumvented it because we're the CC&R's control?
The purpose of the bankruptcy plan was to allow two debtors that entered into bankruptcy to come out of bankruptcy as a reorganized debtor and to sell what was at that point in time their real property. That didn't occur here. They never sold the real property. We had to appoint a receiver in order to sell that real property. And the receiver, there's nothing within the bankruptcy plan. Well, let me take a step back. In order for the bankruptcy plan to be read the way that the Superior Court read it, you have to cross out the word reorganized debtor and insert either lender or receiver. And there's nothing that allowed the Superior Court to do that here. The plain link.
Sorry.
That's okay.
So I just want to get this out of my head before. Had a receiver not been appointed and the owner would have sold the property as was contemplated under the plan,
Right.
you agree that the owner would have had to pay the assessment.
Yes.
So your argument is that because a receiver was appointed, that removes this transaction from the bankruptcy plan, putting it solely in the purview of the Superior Court? I'm struggling.
No, what I'm trying to say is that regardless of the bankruptcy plan, the owner always has the obligation to pay those assessments.
Absolutely. And
Right.
don't we agree that the receiver stepped in as the owner?
I don't. And this is why, Your Honor, because he was a special receiver. If you look at the case law, and I can get there in a second, but there is a specific case talking about when a receiver steps into the shoes of the borrower. Just a second. Well, we discussed it in the briefing, and I'm going to lose it right off the top of my head. But what that case stands for is the proposition that if it is a general receiver over the borrower, over the entity, then it steps into the shoes. But if it doesn't, if it's a special receiver, that does not apply. The case is Gravel Hills, cited in the briefs.
But what is a functional difference between a general receiver and a special receiver in this instance? The owner, the borrower, has walked away from us. It does not functionally exist. It has no assets. It surrendered the property to the homeowners association rather than your client exercising his rights to foreclose. You exercise other rights to have a receiver appointed for the purpose of selling the property that the owner otherwise would be on the hook for selling. So I don't see how the receiver in this case is acting any different than otherwise, whatever you would happen to call it.
And I'll explain to you why. And I think this is explained in the briefing, especially our reply brief as well. When a general receiver is appointed, it's appointed over the borrower. It really functions as the borrower. If it's selling property, it's selling property as the borrower. If it will generate income, say rental income, as a borrower for income-producing property. That's not the case here. Okay, and the HOA was adamant throughout this proceeding that we were dealing with a special receiver because they did not want that receiver to step into the shoes of the borrower. Okay, that's well set out in the briefing. So if you look at the case law, if you look at that Gravel Hills case, it talks, and that's where the step into the shoes of the borrower comes from. That arises in the context of a general receiver taking over a company because it's generating new income. It's generating new pockets of funds to pay.
Isn't in this case, though, the only thing the receiver could generate is the sale of the property?
That's correct. And based on the black letter law that we cite in our briefs, the receiver and the court have to take into consideration, looking at that pool of funds, at the lien priority between the parties. And the lien priority between the parties is that...
Now it's full circle, and we're right back to, you just want us to read out the whole bankruptcy plan.
I don't think the bankruptcy plan applies to the lender, not in this context, because it applies...
Why did you sign it?
We assigned it because we wanted the borrower to be successful in its sale of real property, and the borrower was not successful in the sale of real property.
But you had particular statutory and contractual rights and priorities. As I read it, you surrendered those and agreed to to different priorities that were set forth in the bankruptcy agreement. Otherwise, you could have just stuck by your original priorities that you're entitled to by statute and contract, but there will be consequences to doing that. You chose different consequences by agreeing to follow the bankruptcy plan. So I don't understand why you're not bound by that.
I'm not saying that we're not bound by the bankruptcy plan. I disagree that we waived any rights. There's no language within the bankruptcy plan that says we're waiving our rights under the CC&Rs. There's no language within the bankruptcy plan that says we're waiving our rights under the statute.
But the bankruptcy plan provides different priorities than you otherwise would have had.
It doesn't. All it's doing is acknowledging the fact that the borrower is required to pay assessments when it sells its property. That is a requirement under the CC&Rs, not under the plan.
Well,
Real quick, I got a real quick one before I lose it. If the person, the owner, had sold it and had not gone into receivership, you agree that the owner would have had to pay the assessments before paying your client?
Yes, because the CC&Rs require that.
Okay. So you think because we put a receiver in there, that changes the game? Is that basically your argument in a nutshell?
No, my argument in a nutshell is that I believe the CC&Rs control the situation. They require the owner to be responsible to pay assessments in all circumstances and expressly state that the lender with the first deed of trust is not responsible. And I believe that document controls the situation here. That document was in everyone's minds when they agreed to the bankruptcy plan. There's nothing within the bankruptcy plan that says you can ignore that document. You can ignore those rights. You can ignore the statutory rights. That was never there. And
the only way that the owner can satisfy its responsibility to pay the assessments is to sell the property, because it has no other business. It only owns the property. So when it sells the property, I don't understand how it can say, yeah, I know that we have this bankruptcy plan, but I have to follow the CC&Rs first. I would imagine the bankruptcy creditors would not be very happy with that.
The reason is because before you get to that waterfall, the bankruptcy plan requires the borrower, the reorganized debtor, to market and sell its property. It didn't do that. We had to come in, appoint a receiver, and have a receiver do it as a special receiver, and that is a very important distinction to make. And, Your Honor, I have 56 seconds left. I'd like to reserve the rest of my time for rebuttal. Thank you.
Thank you. Counsel.
Morning, Your Honors. My name is Don Gaffney. I am with the law firm of Snell and Wilmer, and I'm here today with my colleague Emily Wagner. This has been a long and tortuous case, as Judge Brodman pointed out in his rulings in this case. It began with a failed real estate development of a high-end project, a gentleman named Dave Cavan. Dave Cavan convinced a group now called the Recap Investors to buy into a promissory note and debt structure for profit. I mean, it was a profit-making venture for them. It's not a classic traditional commercial loan. The Village at Seven Canyons Owners Association, my client, is the Homeowners Association in operation there. Mr. Cavan controlled that for many years. Finally, the company collapsed into bankruptcy in 2010. During that time period, the Recap Group took control. The actual investors took away control of Mr. Cavan of the debt obligations. Within a year and a half, my clients were able to vote out Mr. Cavan and pursuant to Judge Baum Bankruptcy Court's order, allowing them to step in as the new board. The bankruptcy went all the way through 2013. It resulted in the joint plan that's been discussed already this morning. And as the confirmation order is entered in, first there's the plan, the confirmation order in April 2013, and then there was a closing period in effect till the effective date when the modified notes and deeds of trust were created in May of 2013. Everything becomes effective in May of 2013, May 31st exactly. Since after that, litigation began. Villa Renaissance and the Recap Group immediately got into litigation. This follows the exhibit that we've referenced, where Mr. Gehrig explained to him he was not going to capitalize.
Counsel,
Yes, sir.
we're familiar with the facts.
All right, Your Honor, I'll skip ahead.
But can you talk about this idea of special versus general receiver and what difference that makes?
Yes, Your Honor, I don't believe it does make a difference. There's certainly a difference between a general corporate receiver, which would be charged to dissolve a C Corp, an LLC. There are different dissolution statutes throughout the ARS for each of these entities. This is not a general corporate receivership. I agree with that. It is a special receivership. However, special receiverships do exactly what the court does. The court appoints an officer, and we could go back not only to the deeds of trust, which describe the kind of receivership they can ask for. Let's look at Judge Brodman's order. It said, I'm appointing a receiver to take full control of the property, and included within those specific duties are to pay costs and assessments in the order appointing. It only makes good sense. If you're a receiver and you're taking control of a piece of property, you have to order green paint to paint it. You've got to be able to incur those kind of expenses.
Did the special receiver have to follow the bankruptcy plan? I think is what Judge.
I apologize. I'm going on a wrong tangent. Yes, it did. And again, not trying to draw, higher than thou, federal versus state, but technically a federal bankruptcy court order here would be binding, and would be binding on a state court receiver appointed under a deed of trust, which is already bound by the federal bankruptcy court order. Order was entered in 2013. All the statutory time periods for reconsideration are gone. There is a procedure for modification of a plan or an order later. It's called 1127 of the USC. That was never filed. They never sought a modification. So you have a deed of trust specifically created under the plan pursuant to the restrictions that notwithstanding any default. It says the proceeds of the sale. And the predicate in that line right before subsection D of the section of the plan, the reorganized debtor will market and sell villa fractional intervals. Well, the receiver was appointed under the order prepared by the plaintiff to take control, market, and sell. That's exactly the order they asked for and obtained from Judge Brodman. And then in a joint marketing effort, which they have done, we've worked with them on reasonable terms and conditions. And then you go after the period. Proceeds from the sale shall be distributed as follows. It doesn't deal with who sold it as a restriction. We're not imposing liability against RECAP. We have no right to sue RECAP under this provision. We have a right to have a certain amount of money paid from proceeds. And it's a very specific identified parcel A property.
As I understand the argument by the lender is that the owner owes the assessment, not the receiver.
I would,
And is governed by the CC&Rs and not by the bankruptcy plan. I think you can tell I'm skeptical of the argument, but what's your view on that?
they both owe it. Nothing in these documents or proceedings ever relieved Villa Renaissance, which is an empty shell and has been through its existence, of an obligation to pay. That doesn't mean another person has an obligation to pay as well from proceeds.
If all of the units are sold, but it does not cover the assessment total that's owed, that's owed, VR, or I guess VR will remain on the hook for the remainder of the investment.
That's correct, Your Honor. There's no document ever released Villa Renaissance in any way. That entity would still technically owe. It'd be a deficiency action once you that they would be filing in essence, or a lawsuit in a remainder.
But isn't that taken care of in the bankruptcy plan, though? That VR is forgiven, or
No, Your Honor. VR was created as part of the plan.
Okay.
It was created, literally, the shell entity was created by the new investor group from Boston about approximately 3 or 4 months before confirmation to act as the shell that would hold parcel A. To this day, Villa Renaissance still owes all the obligation of RECAP that is unpaid. They've never been relieved that obligation. Nothing in our arbitration agreement could possibly relieve it. We don't have the ability to exculpate them from that. So that money's still owed from our standpoint. I did want to address one thing before my time runs out to the court, and that is the suggestion we're creating some sort of large exception or rule from this. Quite the contrary. And I think one can only doesn't have to go any further than Judge Brodman's rulings in this case. It is a 27-page ruling. He has, I believe, 5 pages of appendix in very specific findings, including on some points going to the burden of persuasion on those elements. And this is after 3 days of trial and prior motions for summary judgment. So this is a very detailed finding, which, although we haven't discussed it, the secondary ruling on unjust enrichment would exactly do that. I would point out that something that just simply, I think, is a misunderstanding about the statute that was referenced by counsel, and that is he was referring to 33-1256. Now, 33-1256, we agree, is a priority recordation statute. There is no question that that's what it says. If you have this, is where the condominium or the homeowners association falls in the ziggurat of payout. And I'm now talking beyond the bankruptcy court order, which we think bound them to a different order, just as you can contractually subordinate yourself. And that is 33-1256G. 33-1256G, same statute, and it appears in the corollary statute of 1807. G appears in both, and it says nothing in this section prohibits a suit or collection, or actually the term is recovery on the debt represented by the assessment. Why is that important? Because counsel's pointing to the list of liens in order of priority, but as to unjust enrichment, for example, or with the equitable assessment of the receivership operation, those are other actions to collect for the assessment debt. G expressly says this section doesn't control the ability to collect or recover the debt in some other way. And I'll give a further example. Let's say, for example, a lender there was an account that the borrower, Villa Renaissance, had paid into an account in which my client was to be the sole payee of an escrow account. But recap came in and directs the escrow company to pay them. Could my client, even though it's a homeowners association, sue the first lender for conversion? Of course they could. G carves that out. Conversion is a separate form of action in Arizona, just as restitution and unjust enrichment is a separate cause of action. And that's what that secondary level of analysis that Judge Brodman did, which we think backstops or parallels the binding of the bankruptcy court order. Federal bankruptcy court orders on confirmation restricting the rights of secured lenders happen every day and month of the year. That's how they operate. Lenders go into Chapter 11. They may agree to release collateral. They may agree to take interest only for a while. They may agree to suspend payments or reduce the amount of payments. And that's part of the binding contract that my client, their client, entered into and was approved by the Judge Baum during that time period. In fact, by oddity, the only party that's ever tried to file proceedings regarding that plan in confirmation order was recap. They filed a lawsuit, or they filed motions in the bankruptcy court to enforce the plan against Villa Renaissance when there was a brief period where Villa Renaissance was threatening to hold a bulk sale and not get the releases from recap. So we believe they've not only acknowledged the plan, we think it binds them, we think it's binding in this instance on the state court and any receiver appointed over a property and collateral that is controlled coming out of that Chapter 11 plan. After all, the Chapter 11 plan specifically has specifics as to what the debts are, what debts are forgiven, what new debts are being created. So we do believe that's a binding. We also believe that the unjust enrichment case was met here. They're very peculiar facts. Commercial banks don't typically attend homeowners association meetings and hand out letters where they say, I'm the sole representative of recap and we think assessments should be lowered. Most commercial lenders don't negotiate a non-recourse lender where the borrower, prior to signing, the principal, Ben Gehrig, says, we're not going to capitalize this entity, which again goes back to the fact there is only one way to pay under the plan. That's the sales. Rents are not allowed under the CC&Rs. So as the proceeds, which is what is identified in the plan, are paid out over the period of time, then those proceeds would be subject to that kind of assessment going forward.
But you're presenting an alternative argument that was recognized by the trial court.
Yes.
We don't need to reach that. If
I agree. The court does not need to do that. That's why I would stress this decision and very detailed decision by Judge Broman does not require some kind of far-reaching rule to be created or some new exception. It's right there in the plan. Are there other bases to also support it? Yes, we believe they do. But we do think that is binding in this case, and quite frankly, a somewhat simpler and more direct answer to resolve and confirm. My client sued on 7 counterclaims. Only those counterclaims went up, only in 2 monetary counterclaims, leaving aside the attorney fee issue, went up. And both of those we believe are controlled by the Federal Bankruptcy Court plan.
If you succeed, are you entitled to attorney's fees here?
I don't believe so, Your Honor. Cost would be, I think, our limit.
So you admit that you cannot get fees, because I thought you asked for it in your brief.
It may be in our prayer, Your Honor. I apologize if I've missed that, but
This isn't the bankruptcy plan is not a contract.
it is a contract, a form of contract. If it's being enforced purely on that basis under the bankruptcy court order, I'll be candid with the judge. I'm not sure there's any provision in the bankruptcy court code or the plan that provides attorney's fees to be assessed on enforcement of the bankruptcy plan. I'll just be candid there. I don't think we have a right to.
And just so we're clear, so you're withdrawing your prayer for attorneys fees?
Attorney's fees with respect if the court's rulings are based on the bankruptcy court order. If it was under unjust enrichment, then I think we would have a basis. We would seek costs, Your Honor.
Thank you.
Thank you, Judge.
Counsel?
Thank you. I'll make some quick pleas to the court. The first one is that the plan is a contract. That Ninth Circuit precedent states it's interpreted as a contract, and state contract principles apply to it. The CC&Rs were recorded in 2005. This is a 2013 plan, and I asked the court to go back and consider the fact that the CC&Rs were in place and not changed and not waived in any way, shape, or form when that plan was entered into. It was in the parties' minds, and they were relying on the language of the CC&Rs when entering into the plan. And also, I wanted to at least point out the accord and satisfaction argument. I'm not going to have time to get there, but that applies to the 624. And what we're really asking the court to do is to reverse both of the trial court's rulings on assessments, because if not, then we believe this case stands for the proposition that the trial court can use equity to overcome a lender's contractual rights. Thank you.
All right, thank you. We thank both parties for their arguments. The case is deemed submitted. We'll issue a decision in due course.